I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into number 179 on our compilation list. Today, we will be in 3 different judges' courtrooms for this compilation. Before I give you the rundown on the names of those judges, don't forget there will be commentary left in the proceedings from when they previously aired here on the channel. There will be chapters added for your convenience. Don't forget always to like, comment, share, and subscribe. It helps us to push these compilations out to more people. And now let me give you the rundown of the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Shawn Perkins out of the state of Michigan for a classic proceeding that happened some time ago that we aired here on the channel, I believe last year. But for those of you that haven't seen it, it's definitely going to be a treat because it's definitely a classic with a sovereign citizen by the name of Grayson Bay. Some crazy quotes came out of this proceeding. But second, we will be in the courtroom of Judge Sylvia Holmes out of the state of Texas. And for our last proceeding today, we're going to sprinkle in a little non-Sov sit in there, and that will be in the courtroom of Judge Erane, Washington. I hope you guys enjoy number 179. It is a pleasure to bring these compilations to you guys. And listen, let's go ahead and jump on in.
City of Detroit versus Javar Tyrone Grayson, case number SP 1463900, counts 1, 2, and 3. SP 146409991, SP 146436761. Appearance for the record, please.
Grayson Bay.
Sherika Harris on behalf of Mr. Grayson Bay.
All right. Good morning to you, sir.
Your Honor, I'm going to represent myself in this matter. And for the record, my name is Grayson Bay.
All right. City of Detroit versus Javar Grayson Bay. I'm trying to get Mr. Ambrose out of the breakout room, Ms. Snyder. Your offer, sir, is a $240 fine, failure to display, and a seatbelt ticket. You pay those, we'll close the other matters out. That will abstract to the Secretary of State. And then the seatbelt ticket is $65. So $240, $65. We'll close the matters. We'll close the matters out. That'll be a failure to display. It will abstract, but it won't carry any points. And today is the date and time set for a trial.
Your Honor, today was supposed to be set for trial, and I don't consent to any of this.
Okay, it is set for trial. I just gave you your offer so that you can you go in? Okay, there. I just gave you your offer so you could.
I'm not accepting that. I won't accept that offer.
Mr. Corporal Ambrose, can you put your appearance on the record, please?
Good morning, Corporal Brian Ambrose, Detroit Police Department, Badge 415.
Good morning to you. Okay, let's go. Are you ready to proceed, Corporal Ambrose?
Yeah.
Your Honor, I would object to holding this trial. I believe he stated that he's a different person. We have a ticket for a Mr. Javar Grayson. Grayson Bay is an entirely different person. We don't have jurisdiction over, we don't have a case over. I would object to holding that trial.
I'm going to deny the objection. He just said he's Grayson Bay. He just, I don't think he's objecting to the fact.
I object to that, Your Honor. I'm objecting, and I also questioning jurisdiction.
Okay. Well, I'm denying your motion about jurisdiction, sir. The court has jurisdiction over you, so are you ready to proceed, Mr. Grayson Bay?
No, I'm not. I object to anything that you call yourself doing. Also, I like to add that I sent this Brian and brochure. I sent him a COL. It's a cut of law form. I warned him about this situation. This process is also in Wayne County. He's being sued. We can continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. Today. And I will see Brian Ambrosius in 3 weeks in Wayne County.
All right. Well, let's go ahead and proceed because it's not going to be dismissed today. Okay.
Well,
so you can do what you want to do over in circuit court. Then have your way. That is your right. I don't know how you're proceeding in circuit court when you feel that this court doesn't even have jurisdiction over you. So let's go ahead and proceed. Corporal Ambrose, you want to speak with them before we proceed, Ms. Snyder?
Yes, Your Honor, and I do think we just need to clear up on the record that Your Honor has denied my motion to not have this matter heard today based on this defendant saying he is not the defendant before us. And also that defendant has agreed that he is not the defendant before us, but Your Honor is telling us to still do this trial. I need to make sure that's clear on the record.
Yeah, I don't think that he's denying that he's not Javar Grayson Bay. Are you denying that you're not Javar Grayson Bay, sir?
I am the living person, Grayson Bay, in living form.
Okay, so there it is.
However
he wants to articulate it, we'll let him articulate that. He's Grayson Bay. He's Javar Grayson Bay. His mom gave him that name. I don't think that's any dispute. Okay, so
that name has a social security card attached to it. It also has.
I think it's going to be pretty quick, Ms. Snyder. I'll put you in a breakout room with Corporal Ambrose and put it that way. It is just an expired plate, a seatbelt ticket, no proof of insurance. What is this other thing? Refuse to exhibit license and a false information ID. So just join the breakout room, have a conversation with Corporal Ambrose, and then we'll just hear it. And if he has a right to remain silent. He says he doesn't want to be represented by a lawyer, and you can just put your case on the record, and I'll have to make a decision based on that. All right. Rejoin the room, please. I'm gonna pass the matter, Mr. Grayson Bay, and give them opportunity to talk. Okay. All right. We're gonna get her the ticket, give her an opportunity to speak. Are we ready, Ms. Snyder?
My supervisor has advised me to file an interlocutory appeal, Your Honor.
An interlocutory appeal on my motion, on your motion?
Yes, Your Honor.
Okay.
Or I suppose time to brief the issue, maybe on this record, or I'd leave in Your Honor's discretion.
Let's see does that interlocutory appeal, if that is
I'm sorry, Your Honor. Are we back on the record for Grayson?
Yeah, let's go back on the record with Mr. Javar Grayson Bay. Now, is that interlocutory appeal? I mean, I have to proceed. I mean, I got the discretion of whether I want to allow you to do that or not, or just proceed, and you can file your appeal. Correct? Give me the law on that. You're muted, Miss. You're muted, Miss Snyder.
I'm sorry, Your Honor. My supervisor is talking to me over the wall, so it's hard to hear two people at once.
Okay.
The court rule is, I think she might be coming back. It's MCR 7.205.
Be quiet.
MCR 7.212C. 212C.
Maya, come here. Yeah, I'm gonna go on the pool. Handstand is gonna keep them, go get a can. Hurry up.
205, application for leave to appeal, and you said, what was the, citation, what were the other,
7.212, but that's just saying the format for briefs.
I have 7.205 as application for leave to appeal. And this is Court of Appeals.
You have 21 days.
Appeals to Circuit Court, 7.105.
105.
So 7.105, application for leave to appeal. I'm reading from Erane B. 1D. If the order appealed is interlocutory, setting forth facts showing how the appellant would suffer substantial harm by awaiting final judgment before taking an appeal.
Yes, Your Honor. So my answer to that, I just made it to that part of the order too. My answer would be that the people would suffer harm because the defendant has already stated that he is filing what we believe, of course, to be frivolous, but you know, the facts will prove themselves as they go.
Hold on, you broke up a little bit.
Can you repeat the last few words? I'm sorry, you broke up during the statement.
We believe that the substantial harm that the people would suffer would be the defendant has already stated he's filing numerous lawsuits against the court, against the parties, against the officer. We believe we'd be giving him a golden parachute. It's just one more issue to add to his level of appeals. This is one issue that needs to be clarified. Of course, he will be found, I believe, through fingerprints to be either the person given that ticket or Javar Grayson, the person given the ticket, will be given a capias warrant and we can move on. But I do believe that this issue needs to be handled before we make a further record. I have a duty to mitigate the city's damages. And I believe that's what we're doing and what I was advised to do by my supervisor.
But how would the city be harmed at all if we proceed? What would be any harm for the city? Especially if you acknowledge the fact that you think that by fingerprints that would be Mr. Javar Grayson.
But Your Honor, what we think and what we can prove as a matter of the record and as the court of law is different. I do understand. I believe he's being frivolous. I think he is wasting the court's time. But I do think that as lawyers, as a court of law who do have to face appellate issues, this is something that we need to clear up on the record and have a clear record, such as a chain of custody of who Mr. Grayson is. I don't think it would take that long. Or we could solve this today with giving Javar Grayson a capious warrant and let Bay, whoever he may be, go on about his business. Either or. But I do think that having this trial over both of our objections is not the correct answer.
I just don't feel, I just don't feel,
You can't send
one, I don't see any harm in proceeding. He's already indicated that he is Javar Grayson, except he wants to be acknowledged as Javar Grayson Bay, or he's the living, I don't know how he termed it, person of Javar Grayson Bay. I don't think that, as a matter of fact, when Corporal Ambrose came in the room and introduced himself, I saw Mr. Grayson Bay sort of kind of had a look on his face. And to me, I took that look as he knows Corporal Ambrose. And there's no question, I haven't asked Corporal Ambrose is if this is the person that he pulled over, but I'll definitely let you ask Corporal Ambrose that. But I don't think that there is any sort of identity issue here. I think the issue comes into something that we've seen probably, I don't know how many times, and I'm sure we're gonna see it more in the future. And I agree that those things are frivolous and they do not apply. So I don't see anywhere where we can't proceed with this. Not unless Corporal Ambrose says that to you and through you that this is not, I don't recognize this person that's here. And was this not the person that, or even if there was, I would even allow Mr. Grayson Bay to put on a identity defense and say that wasn't me. He didn't. That wasn't the defense. I don't know what his defense is going to be.
Your Honor, may I?
No, you can't. No, you can't. No. When I ask you to, when I want you to speak,
No
I'll allow
problem.
you to speak. I'm going to give you that opportunity.
No problem.
So to settle this matter about your objection, it's like if the court rules bound me not to proceed because you wanted an interlocutory appeal, then that would be the court rules would bind me to do so. But I don't know of a court rule that's going to bind me not to appeal. And I just don't see in what harm it will be to any other parties, the defense or the city, by us proceeding in this fashion. I understand he's got cases over in circuit court. He may have cases over in federal court. I don't know. But here again, we're here. The parties are present, and I'm satisfied at least that that's the Mr. Javar Grayson Bay. That we have the right person here in court today. So I'll let you make a last minute record, Ms. Schneider.
Can I just have one? My supervisor walked away. Can I have 1 second to go talk to her?
Yes. Now you can. Let's see if you want to. If Mr. Grayson has anything, I'm gonna allow him an opportunity to speak so you can hear what he has to say. Go ahead, Mr. Grayson Bay.
Your Honor, I sent you a declaration of notice stating who I am and the fraud, Javar Grayson. I sent you the paperwork. This was over 3 or 4 months ago. I'm pretty sure you have plenty of time to read and understand the situation. And that, like I said, again, that is my declaration of notice. You should have that in the file as we speak.
Anything further?
And I object to this. And again, your court system has no jurisdiction over it.
Give me a point to a court rule or put your legal objection on the record. What is your objection?
My objection is jurisdiction.
Okay, I deny that objection. All All right, go ahead, Ms. Snyder. We'll pass the matter. We'll allow you to speak with your supervisor. Let's go back on the record with Mr. Grayson Bay. Are you there, Mr. Grayson Bay?
Yes, I am.
What I will do, listen, Ms. Snyder, let's go back on the record with Ms. Grayson. What I will do is I will pass this matter and I will reset this trial date for an in-person, because I think this is one that needs to be in person. We can't, it's been some stuff that Mr. Grayson Bay has said that he has filed with this court. He says he sent me some stuff. I don't have that in front of me. There's it in the file. And this one seems like it's going to necessitate some, it's going to necessitate a trial, and I think that this one is best to be done in person. So what I will do is I will reset this trial date. That will give me an opportunity, one, to get the documents that, if they exist, that Mr. Grayson Bay has said that he has filed with this court. And then two, that'll have both of the parties here in person. All right, so I'm going to reset this matter for a January 9th in-person trial date. Now that is going to do. Now let me ask you this, sir. You understand you have a right to a trial by jury, correct? Mr. Grayson Bay?
I'm just challenging jurisdiction. Also, for the record, I sent Detroit Police Department 12th Precinct a declaration of notice. I also sent them a COL, which is a color of law.
Listen, Mr.
Under
Grayson
law.
Bay. Listen, Mr. Grayson Bay. I don't care about that stuff. All I care about is what's here before me right now.
Okay. Did you get the declaration of notice?
I don't. If I did, it's not in the file. I'm not going to say I didn't.
Okay, I'll send you another copy.
Let's make this a jury trial too.
I send you a copy. No, it's not a jury trial.
No,
you have the situation in your hands. No jury trial. You have the situation in your hands. Make a decision today, Your Honor. Make a decision.
I don't know why you made it.
Can I have a breakout room with Mr. Grayson?
No, it's not going to be a breakout room with him. Let's get him a jury trial date.
Oh, jury trial.
Yes. Let's just go ahead and he's not running this show.
I have Judge Carpenter.
Okay.
Do you have somebody like you want to assign to this case?
Not necessarily. I mean, anybody can, I'm sure, handle it.
Okay, that's fine. Thank you, Judge.
Yeah.
Let's get it.
If Miss, I'm not talking to you, I'm talking, let's go off the record. Miss Harris, do you want the case of Gomez Lopez?
No, thank you, Your Honor.
Okay.
I can't hear him on
By ear.
No, it's not. We're not talking about your case. We're off the record with your case. We get a jury trial date. Let a jury of his peers make the determination.
And I think we'll clean up the record issue with him in person.
Judge, let me know when you're ready for the date.
All right, let's get a jury trial date.
He's and so it's the 17th. The next day will be.
The 14th of November. Let's go back on the record with Mr. Javar Grayson, the 14th of November.
Maybe we should do December. Let's see how December is.
Look at December the 5th. Tuesday, December the 5th, jury trial. Let's not schedule anything else on that day.
Okay.
Tuesday, December the 5th, 9 a.m. we will do. As far as motions are concerned, I'm going to set some motion dates. So, what was that comment, sir? Mr. Grayson Bay?
Yes, sir. What's going on?
Was that comment?
No comment. Listening. Let's go.
All right. Let's set a motion date for November the 10th. That's when Mr. Grayson.
That's Veterans Day, sir.
By your
Oh, no,
ear.
Okay, good. Let's set motion the motion will be due by motions due by November the 9th. That's for both parties. The responses to the motions will be by November the 17th. And we will set a final pretrial date a day before on December the 4th, 2023. So technically, you'll have a court date that can be, it could be on Zoom for the final pretrial date of December 4th. If there hasn't any resolution, I'll get my ruling on the motions on that day. And then we'll set the jury trial date for December the 5th, 2023 at 9 a.m. All right? You got that, Mr. Grayson Bay?
No, you gave me 10 dates, but what I'm going to do is I'm going to send you a declaration of notice.
I did not give you 10 dates.
I count, let's see, 1, 2, 3. I got December the 5th, December the 4th. I got November the 9th. I got also November the 17th for a response. That's 1, 2. That's like what, 5?
I counted 4. You counted 10 at first. And now you're counting 5.
I just want to get this matter resolved, man. I just want to get this matter resolved.
I'm not your man.
Let's resolve it today.
It's not gonna be resolved today. Come back. Well, you got the dates. Motions due by November the 9th. Responses are due by November the 17th. Final pretrial date December the 4th. I'll rule on the motions on that day, and then jury trial date December the 5th. Have a great day, sir. Best of luck to you. December the 5th at 9 a.m. The pretrial on December the 4th is at 8:30. Best of luck to you.
Thank you, Your Honor.
All right, thank you. That'll conclude it. Good morning. You all right?
Thank you, Your Honor. Have a good day.
Corporal Ambrose, you be safe out there. Very good to see you. Have a good day.
Good to see you. Have a good one.
725 Urban Oaks doing business as Urban Oaks versus Jose Martinez, Nicole Lewis, and then the other occupants of 6725. So who do I have on behalf of Urban Oaks?
Keith Wolfshall, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Do I have someone for our first defendant, Jose Martinez?
Yes, we're here as a special appearance only, and Nicole is also in a special appearance as well.
All right. Mr. Martinez, what is the reason you're saying it's a special appearance?
This is a special appearance because we are challenging jurisdiction and we do not participate in legal contract.
Okay. What is the reason you don't think the jurisdiction exists?
Because it has to be proven. Whenever there's a challenge.
That's not a jurisdictional thing. Jurisdiction is either it's something I can't hear, but evictions are solely the province of a justice court. So the only other jurisdictional issue would be if the property is not located in the precinct. To your knowledge, does that address physically fall within the bounds of precinct 3?
I don't believe it does, that there's no personal jurisdiction. there's no personal jurisdiction. There might be subject matter, but in order to hear a case, you have to have subject matter and personal jurisdiction at the same time.
Mr. Martinez, if you're appearing in court, you've been served, and if you are indeed an occupant, then that would be sufficient for them to have personal jurisdiction and for the court as well.
That's why we're challenging jurisdiction. And the law says that whenever we challenge jurisdiction, that the court cannot proceed unless they provide to us, both of us, Nicole Lewis and Jose Martinez, proof that y'all have any jurisdiction.
All right, well, I'll take the information from Urban Oaks, but we'll find out. All right, then, Mr. Wolfshaw, please tell me first, why don't we address the jurisdictional issue? Is this property located within the bounds of Precinct 3?
According to the maps of Travis County, yes, Your Honor, they are.
Internet just like a hall. I can't hear
the maps.
Mr. Wolfshaw, I was not able to understand you. You broke up a lot.
I'm sorry, Your Honor. Is this any better?
That's better. Okay. Tell me about location. Is it in Precinct 3?
My apologies, Your Honor. Can you? Okay, thank you. Yes, Your Honor. According to the maps of Travis County, the precinct, this property does lie within the precinct of Precinct 3, jurisdiction of Precinct 3. We'd ask the court to take judicial notice that 6725 Urban Oaks is in this precinct.
On Circle Road at Congress and William Cannon? Mr. Wolfshaw, is that the address?
I'm sorry, Your Honor, you're breaking up on me?
Is the address 6725 Circle Road?
I'm sorry.
Mr. Wolfshaw, your internet
I'm sorry, Your Honor.
This is bad.
I'm sorry, Your Honor. The address is 6725 Circle S Road, Austin, Texas, 78745.
All right, I pulled it up on the map. That is within Precinct 3. So we have both personal jurisdiction and subject matter jurisdiction. So Mr. Martinez, Mr. Lewis, I do find that jurisdiction exists within our court. All right, Mr. Wolfshaw, I'm sorry, sir?
We don't consent to that unless it is proven to us in writing that there is jurisdiction.
Mr. Martinez, I'm saying that I found proof sufficient. You can appeal if you don't agree. Okay?
Well, no, that's not the law. The law says that we have to go to
the law, Mr. Martinez. As long as you are showing up, the plaintiff need only show me that they have served the defendant in the result, which you've not denied that you are Jose Martinez. He has established for me that is an eviction wholly within the precedence of a justice court, and that the address for which the eviction is sought is one which is in my jurisdiction. That is all that is needed.
But also it says that we don't participate in legal contract, and that would be...
Mr. Martinez, are you currently residing in the apartment they're trying to evict you from?
I don't understand your question, and I don't understand your jurisdiction.
Mr. Martinez, I'm going to ask that you just be silent and let me go through the plaintiff's case, and then I will answer all of your questions for you. Okay? All right, Mr. Wolfshaw, so it's an address that's in the precinct. What's the reason the eviction's being sought?
Your Honor, this is an eviction for non-payment of rent.
Non-payment. Is there a written contract with the defendants?
There is, Your Honor. It was entered into on November 6th, 2024, and it expired on October 31st, 2025. We're now in the secondary phase.
Mr. Wolfshaw, is that contract with Jose Martinez and Nicole Lewis?
It is, Your Honor. There is a copy that was provided to the court as well.
How much is the monthly rent per that lease?
$1,464.
All right. Any subsidy?
It is not, Your Honor.
Mr. Wolfshaw, you broke up. Was that a yes or a no?
No. The last question is, it is not subsidized, Your Honor. It is not subsidized.
What months of rent have been unpaid?
October through the present.
Is this a CARES property?
It is, Your Honor.
And when was the notice provided?
September 10th of 2025 I apologize, Your Honor. I did not write that down. Give me just one moment. Let me make sure I'm telling you the truth. All right. It was by first class and certified mail on September the 10th, 2025. It was also a 30-day notice to vacate.
All right. To your knowledge, the tenants have not vacated?
They have not vacated, Your Honor.
Okay. What unit number is it, Mr. Wolfshaw?
Yes, Your Honor. That is going to be unit 1240.
All right. Mr. Martinez, Ms. Lewis, good morning. Mr. Wolfshaw says that you have a lease with the apartment complex for unit number 1240, and he provided me with a copy of that lease. Do you recognize this document?
Yeah, that contract is expired.
Is this a contract that you entered into, Mr. Martinez?
That's not the original one. The original one was signed in wet ink. That one is signed by electronic signature.
All right, so you have a contract that you signed. Is it for the apartment number 1240 there at 6725 Urban Oaks?
It was, but it's expired.
All right, are you still currently residing in unit 1240?
Yes, we are.
When's the last time you paid rent?
I'm not sure.
All right, the landlord here says that the rent is $14.64 a month. Is that correct?
I'm not sure because we were getting assistance from a foundation for the home
lease. What does it say in the lease that you said you signed? On this one, I see it to be $14.64.
Right. That's probably the foundation was paying for that. So they were the ones that were doing all the paperwork for us.
Do you have any proof that they are paying the rent on your behalf? Because the lease says that y'all owe it.
Yes, we do have proof. They were sending checks from City of Austin Foundation for the Homeless to the apartment complex that they were paying the rent.
All right. Do you know if rent has been paid for October?
I'm not sure.
Ms. Lewis, do you know if rent has been paid on behalf of October?
I'm not aware.
All right. And Mr. Lewis or Mr. Martinez, Ms. Lewis, have either of you made payment, or do you know if payment has been made for November?
We're not sure.
All right. Well, they do find the landlord has met their burden then to show that per their information in the ledger and the lease, rent remains unpaid for the past 2 months. Mr. Wolfsham, are you wanting to prorate the rent through the hearing or through the appeals deadline?
Your Honor, just for today, I calculated that as $3,028.
All right. So you are prorating?
Yes, Your Honor, we're prorating.
Today is the 18th. So for 18 days, I got $48.80. So that's $878.40. So with that and the $14.64 for October, judgment for the plaintiff, $2,342.40. If either party wishes to appeal, we'll put that at just the 1 month of rent. That'll be $14.64. Ms. Martinez, Ms. Lewis, you both have at least 5 days to appeal before the landlord can seek a writ of possession. We will send you the information related to that. I'll highlight for you, for all parties actually, in a non-payment case, you may be able to appeal, and if you've been receiving assistance from a rental agency, you might even qualify to appeal for free. However, if you want to stay in that apartment while the case is being heard to another court, you do have to pay full rent of $14.64, but you pay it to the court, and we'll send you specific information about that. All right. Any questions, Mr. Martinez, Ms. Lewis?
Okay. Yeah. We also submitted a VAWA case, Violence Against Women's Act, that was also violated back in July. And we submitted the VAWA Act. So they're in violation of the VAWA that prevents us from being evicted according to VAWA Federal Act. And we submitted it and they did not respond or help us on that VAWA Act.
All right, Mr. Martinez, unfortunately, that does not work as a defense to non-payment. I would absolutely encourage you to reach out to legal aid with that issue and with the others and see if they can assist you. You have at least 5 days. If you take no action sooner, day 6, the judgment becomes final. All right.
We don't accept or consent to the law, the orders. So.
All right. Well, Mr. Martinez, whether you consent or not, that is the order of the court, and it will become final, and the judgment would be sufficient for the landlord to move forward with a writ of possession and removal of you and your property. So please contact legal aid in the next several days to see about an appeal. All right.
Well, we don't call legal aid.
Good luck. All parties are excused. Thank you.
All right. The court will call the matter of Ypsilanti Township versus Kamisha Gardner, case number 25T00229.
Paul Barnett on behalf of the township.
Yes, good morning, Your Honor. If it please this honorable court,
Brandon Bird on behalf of Jamisha Gardner. Ms. Gardner, can you please state your full name for the record?
Ms. Gardner, you need to unmute your device, please.
I'm sorry, they stole my phone and I'm working off of a tablet. I gotta figure out how to do this. Can y'all hear me?
Yes, we can. Please state your name.
Miss Washington, I love you. You know what?
Ms.
I just
Gardner.
want to tell you. No, I ain't talking to you. I'm talking to her.
Can I see counsel in the breakout room, please?
I just want to tell you, I
Yeah.
love you so much.
All right, we are back on the record in the case of Ypsilanti Township versus Jamisha Gardner. Ms. Gardner, can you come back to the screen? All right, you're
Can you hear me?
yes.
Hey,
Ms.
can you hear me, Miss Washington?
Yes, I can, Ms. Gardner.
Okay.
So,
We
Ms.
good.
Ms.
It go
Gardner,
in and out sometimes on this tablet. I don't really know how to work this thing. And sometimes when people be calling me, it just drops silent. I don't know. I'm trying to work it though.
yeah, well, you're doing just
I
fine.
love you. Guess what?
Miss
I know your
Gardner,
brother Tony.
I don't
Ma'am?
have a brother named Tony. I don't have a brother named Tony.
Yeah.
So,
I know him as Tony.
no, I don't have any brother that goes by
You
Tony.
can't talk. Do you know Anthony Johnson?
Miss Gardner?
Your ex-boyfriend?
I don't have an
He
ex-boyfriend.
trying to be my man right now. He mad at me because I don't want him. Your
Ms.
ex
Gardner.
says,
Gardner? Ma'am,
Anthony,
this is
Anthony
definitely
Johnson. Do it ring a bell?
You dated
That
Anthony Johnson.
he
Miss
ain't
Gardner,
gonna never
please stop
shit.
talking.
And I'm glad you ditched
Please
this
mute.
bitch.
Miss Gardner, you are going to end up going to jail today, or you need to go over to community corrections and get on the scram tether because you're clearly drunk right now. So you need to go to community corrections. You need to find a ride there by the end of the day today and get on the scram tether. Okay? If you don't go by the end of the day, then you're going to force me to issue a bench warrant and have you picked up, which I don't want to do. But you got to get on a tether because you're drunk. There's no way that we can proceed today with this pretrial. Obviously, Ms. Gardner is completely out of control right now. And I'm going to give her the benefit of an opportunity to get on the scram tether before she gets incarcerated. So, Attorney Bird, hopefully you can reach out to your client and be able to get her over to community corrections in some way, shape, or form. Mr. Barnett, is there anything you wanted to say before we pass this case?
No, Your Honor, I support the steps you're taking right now. That's fine.
I do also, Your Honor.
All right. And for the record, I don't have a brother named Tony, nor an ex-boyfriend named Anthony Johnson. So have a good day, Miss Gardner. You can remove her.
And you and your Honorable Court have a great day, Your Honor.
Thank you. I'll send him a date. It's not going to matter to give it to her anyway. I'm going to put it on for September 10th. No, I'm not. I need to see her before that. I'm going to put her on for September 3rd. At 9 a.m. And I've been trying not to go forward.
Well, guys, we come to the end of this very, very, very short proceeding for Miss Gardner. As we can see, she definitely was intoxicated. Once we all heard her say, Judge Washington, I love you. We knew, the judge knew, obviously her attorney knew because he tried to jump right in that something was wrong. But, you know, Judge Washington did get a little kick out of it earlier on. But as the proceeding went on, especially after the break, Judge Washington was pretty much fed up with everything. Especially with her accusing Judge Washington of having a brother and some ex-boyfriend. And we see Judge Washington also tell her, listen, you need to go and get on the scram tether, excuse me. And if you do not do that, you will be going to jail by the end of today. And if you don't know what a scram tether is, basically it's a bracelet that monitors your location, but not only monitors your location, but also monitors if you are consuming alcohol. But with that being said, we see she's been given a continuation, and we're going to try to follow up on this. But I did want to share this. I thought it was interesting, even though it was really quick, but I ran across it just watching some of the Michigan proceedings. So I just wanted to share it with you guys. But with that being said, guys, I don't know why I'm so tongue-tied today. It just seems like I'm just fumbling my words. But with that being said, guys, as always, I appreciate you guys for joining me here at Sovereign Citizens Hall of Fame. And until the next time, guys, we get together again. I appreciate you guys. Don't forget to like, share, subscribe, comment, whatever it is that you feel you need to do to be a part of this community. Thank you. And until the next time, guys, God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.